Assalamualaikum warahmatullahi wabarakatuh to Ms. Shamim. Before we start our presentation, we are going to introduce ourselves first. My name is Muhammad Izkil bin Zakaria and I will explain for scene 7 and scene 8.
Assalamualaikum warahmatullahi wabarakatuh to you, Ms. Shamim. My name is Muhammad bin Miskandar bin Ahmad Faisal and I will talk about scene 1 and scene 2.
Hello and Assalamualaikum to our lecturer, Ms. Shamim. My name is Syazah Adlina binti Suhairi from 2L, and in our video presentation, I will be focusing on scene 5 and scene 6.
Hello everyone, I hope you guys doing fine in face of this COVID-19 pandemic, especially for Ms. Shamim and my friends. So, I am Meliana Pomin, will present about the scene 3 and scene 4.
That's the end for our introductory session. So now we are going to present a case about express condition. Let's start.
This is the plaintiff, and this is the defendant. This is a court case between Equivas Hotel Management vs. Musang College Agenda Sdn Bhd and Anno 2014. Scene 1. The plaintiff was interested with the property. Upon seeing the plaintiff's interestness, the defendant offered an amount of price of the property, and both of them reached an agreement for the property. Scene 2. The next day, both of them meet to discuss and sign the agreement regarding to the property. The plaintiff signs it and calls it as a deal. Both of them reach an agreement.
So this is the agreement that have been declared on 25 October 1998 by the plaintiff and defendant. By an agreement date of 25 October 1998, the agreement have been stated that the plaintiff agreed to lease 9 lots, all in the Mukim of Padang Mat Sirat in Langkawi, Kedah. Plaintiff stated that he will lease the property for a period of 25 years commencing from 1st January 1998 and ending on 31st December 2023 for a monthly rental of RM250,000 ringgit. The second defendant is the holding company of the first defendant, and it is in the business of providing education. It also understood between these two parties that the leased property is to use by the defendants as a college and university campus. Among the silent features of the said agreement is that the plaintiff undertakes to complete and repair and obtain a certificate of fitness for occupation in respect of the said property for the defendant's business period to deliver of vacant possession of the same, which was agreed to be on or before 30 November 1998. It is also agreed that on or before 1 December 1998, the plaintiff should deliver or submit to the defendant with rental free for several months before the date of commencement of vacant possession of the property, along with certificate of suitability for employments and with the consent of all relevant authorities and upon completion of the repair. On 1 December 1998, both of the defendants went to take the partial possession of the property. And they come back to the property on 14 May 1999 to take the possession of the whole property.
Moving on to our scene 5. not so long after the defendants took the whole possession on 40 May 1999. Defendants found that something was off and checked the contract about the agreement with plaintiff. Somehow, defendant found that plaintiff failed to obtain certificate of fitness for occupation. The defendants then make a decision to check the property whether it's in good condition or not as claimed by plaintiff. The defendants shocked as the property is not in good condition and tenantable condition. The plaintiff has failed to complete the repair works. The defendants then make a complaint to plaintiff as dissatisfaction. This is where the argument between plaintiff and defendant happened. Plaintiff got a complaint from defendant by saying that he has breached a contract to repair the property as in agreement. Not only that, he also have failed to obtain the certificate of fitness for occupation. Based on our contract, the property and the money that have been invested by defendants. Defendants claim that the plaintiff promised that he will deliver the property in good condition. Second, promised to repair the property. And the last one, plaintiff said to defendant that he will obtain the certificate of fitness for occupation. During the meet, when defendants and plaintiff check the contract again, suddenly the plaintiff denies about the agreement. Somehow, plaintiff also said that the defendant have an arrears of rent. This is what the plaintiff statement. Plaintiff claims that the defendants are in arrears of rent. Second one, the defendants has failed to provide a bank guarantee of RM50,000 as agreed and issued a letter of termination to the defendant dated 18 October 1999. Third one, the defendants however stayed and keep on paying rentals to the plaintiff. Because of that, defendants have put a statement that plaintiff has wrongfully terminated the lease.
When he on his way to go back to his office, he has been thinking about how to settle his problem. And then, he decided to hire a lawyer because that's the only way he can solve his problem legally. He continued walking back to his office. After that, the plaintiff is preparing the document that he need to bring and show to his lawyer. At the same time, he also searching for a good lawyer to hire by doing some research and checking the background of the lawyer. Once he found, he set an appointment with the lawyer when they are going to meet. Soon, the plaintiff met his lawyer and tell everything happened. He also seek some advices from the lawyer and the lawyer explained potential things that will happen when filing a lawsuit. They were having consultation session until the trial day. Here comes the trial day. Both of the lawyers are presenting their client's document and evidence to the jury and judge. Once the attorneys for both sides have presented their evidence, they each will give closing arguments and followed by jury's verdict. So hear what the jury said. For the above said reasons, on this ground of illegality alone, I find sufficient reason to hold that the plaintiff claim is unsustainable and it will be an exercise in futility to venture into the other issues raised. The plaintiff claim against the defendant is hereby dismissed with cause. So, why the plaintiff claim is dismissed? The answer is, the plaintiff was fully aware that the subject property was developed in contravention of the condition of land use ever since the property was first developed as a hotel resort. A breach of condition as to land use would expose the property to the forfeiture under Section 127 of the National Land Code, and the lease agreement between the parties clearly defeated the provisions of law relating to the same. As such, the lease agreement between the parties was void under Section 24 of the Act. Based on the ground of illegality alone, the plaintiff claim was unsustainable. Further, it is a principle of universal application that a party ought not to be permitted to take advantage of his own breach. Second one, the enforcement of the present illegal contract was also contrary to public policy. So, That is the reasons why the plaintiff claim against the defendant is dismissed with cause. And before we end our presentation, this case is really good for us to refer on because it is related to part of our syllabus, that is express condition under chapter 5, condition and restrictions. So that's all from us. Thank you.